Have you ever heard of Dr. Jack Kevorkian? Dr. Kevorkian helps people die. He believes that people have a right to terminate their life if they wish, and he provides them with the medicine necessary to do it quickly, painlessly, and in his view, with dignity. He works with terminally ill patients, often in excruciating and uncontrollable pain. But what Dr. Kevorkian does is illegal, and the state of Michigan, where he lives and practices, has prosecuted him unsuccessfully several times. In 1999, however, he was convicted of second-degree murder and sentenced to a prison term of 10 to 25 years. Should the practice of physician-assisted suicide be illegal? Who should make this choice? The legislatures? The courts? Individuals? John Stuart Mill, the 19th century British philosopher, offered a broad definition of liberty. In an 1859 book called On Liberty, Mill wrote the following: "The only freedom which deserves the name is that of pursuing our own good in our own way, so long as we do not attempt to deprive others of theirs or impede their efforts to obtain it." Under this theory of liberty, people should have the right to end their lives. What could be a more fundamentally important and private decision than the decision to terminate your life? Is Mill right? On the other hand, many people believe that helping individuals to end their lives violates the sanctity of human life. Others worry that asking doctors to help people end their lives violates doctors' Hippocratic oath. Still others point to a potential abuse. There might be pressure on older people to end their lives so that relatives and children get their inheritance sooner, or to relieve the burden on the family. This question, like so many others in the U.S., has been discussed in the courts as well as the legislatures. And it has taken two forms. One is the withdrawal of life support. The other is physician-assisted suicide. Let's get a precise definition of that. Physician-assisted suicide occurs where a physician prescribes medication to a terminally ill patient that causes death. It's contrasted with euthanasia, where the doctor directly administers the lethal medication. Now, the first set of cases to deal with this general right were the right to refuse medical treatment when that refusal would lead to death. The issue was first litigated in New Jersey state courts in a 1976 case known as In re Quinlan. Karen Ann Quinlan was a young woman who was in a coma from age 21 to 31, kept alive by a respirator. Her parents wanted the respirator removed, but the medical staff at the hospital refused to remove it. The Quinlans went to court, and the New Jersey Supreme Court ruled that a patient's right to privacy included the right to refuse treatment. The court held that a patient unable to speak for herself, like Karen Ann Quinlan, can exercise that right through a family member or a guardian. In 1990, the U.S. Supreme Court heard a similar case, Cruzan v. Missouri. And this case involved Nancy Beth Cruzan, who at age 25 suffered severe injuries in an automobile accident that left her in a persistent vegetative state. She was kept alive by feeding and hydration tubes and showed no signs of significant cognitive functions. Her parents sought to discontinue the tubal feeding, but the state of Missouri, claiming an interest in the sanctity of human life, refused. A Missouri trial court ordered the removal of the tubes, holding that there was no state interest that outweighed Cruzan's right to liberty. However, the Missouri Supreme Court reversed, holding that there was insufficient evidence for determining Cruzan's wishes. The standard the Missouri Supreme Court held was clear and convincing evidence. The case was appealed to the U.S. Supreme Court. On appeal, the U.S. Supreme Court upheld the Missouri Supreme Court's decision, but by a vote of 5-4. However, most of the justices appeared to acknowledge a constitutional right to refuse treatment, at least under certain circumstances. Justice Brennan, writing for himself and two others in dissent, argued that Nancy Cruzan is entitled to choose to die with dignity. A few months after the U.S. Supreme Court decision, the Cruzans asked the state court for a new hearing on evidence of Nancy's intent before the accident. And this time the court found that Nancy Cruzan, if mentally able, would remove her tubes, and the court authorized their removal. She died less than 2 weeks later. An even more difficult issue is physician-assisted suicide. In 1991, voters in Washington state rejected a ballot initiative allowing a form of physician-assisted suicide, as did voters in California in 1993. In 1994, however, Oregon voters enacted through a ballot initiative a Death with Dignity Act by a slim 51 to 49% margin. The act legalizes physician-assisted suicide for competent, terminally ill adults. Under the Oregon law, a physician may prescribe medicine to cause death in certain limited circumstances, but may not directly administer medication to end a life. In both 1999 and the year 2000, 27 terminally ill individuals made use of the law. There was a federal response. In April 1997, President Clinton signed the Federal Assisted Suicide Funding Restriction Act, prohibiting the use of federal funds in support of physician-assisted suicide. Then in 1997, the Supreme Court heard a case attacking a ban on physician-assisted suicide. The case was called Washington v. Glucksberg, and it came from the state of Washington. Washington had a law that prohibited physician-assisted suicide. And the question in this case was, is there a constitutional right to die that's protected by the Due Process Clause of the 14th Amendment of the United States Constitution? The lower courts said yes, and they invalidated the law. The state appealed to the U.S. Supreme Court. The U.S. Supreme Court was unanimous in upholding the law. Chief Justice Rehnquist wrote the opinion for the court. He said that history supported a state ban on physician-assisted suicide. He noted that it had always been a crime to assist a suicide in the state of Washington, and then he claimed very broadly that for over 700 years, the Anglo-American common law tradition had opposed suicide. Indeed, when the 14th Amendment was ratified, including the Due Process Clause, the Chief Justice pointed out that it was a crime in most states to assist a suicide. But by its language, the Due Process Clause of the 14th Amendment protects liberty. So the court addressed the question of whether it should read into that notion of liberty an individual right to obtain assistance in ending a life. The court concluded it should not. Its standard was this. The Chief Justice wrote, "We've always been reluctant to expand the concept of substantive due process because guideposts for responsible decision-making in this uncharted area are scarce and open-ended." So what the Supreme Court did was to fall back on its traditional approach to deciding if a right was protected under the Due Process Clause. The court held that to be protected, a right must be deeply rooted in this nation's history and tradition, must be implicit in the concept of ordered liberty. Chief Justice Rehnquist stressed that these fundamental rights are found to be deeply rooted in our legal tradition and that physician-assisted suicide simply did not meet these conditions. The court also distinguished the right to physician-assisted suicide from the right to direct removal of life-sustaining medical treatment, as in Cruzan. It pointed to a common law rule against forced medication. And it also pointed to other state concerns. It said their state might find a difference between harming and healing. A state might have an interest in protecting vulnerable groups, including the poor, the elderly, and disabled persons, from abuse, neglect, and mistakes. And the court said the state might believe there was a slippery slope, that if the state adopted physician-assisted suicide, it might start down the path to voluntary and perhaps involuntary euthanasia. The Supreme Court concluded by pointing out that its decision left the states free to act if they wish. As the court put it, our holding permits this debate to continue, as it should in a democratic society. Now, there were several concurrences, and they suggested a somewhat broader view. The same day, the court also decided a case from New York called Vacco v. Quill. And what the court did is it upheld a New York statute which prohibited physician-assisted suicide but allowed patients to refuse life-saving medical treatment. The right to die involves some of our most deeply held beliefs about life and death. As the baby boom population ages and medical technology prolongs life, the debate is likely to intensify. For the most part, the courts have approached the issue delicately. The Supreme Court, in its most recent Glucksberg decision, held there is no constitutional right to die. It held that the Constitution leaves that question to the states and to the people. In a democracy, some people believe, this is where the decision belongs.